Good morning, students. Today we will be dealing in this session with the National Commission for Women. Okay. Now we see many articles being provided by the framers of our constitution. Okay, in the Constitution of India that deal specifically with women and try to safeguard the rights of the women. Okay. For example, Article 14 it says that the it carries the principle of equality and says that no person should be denied equality before equality before the law or the equal protection of the laws. Okay. Similarly, Article 15(1) it also talks about equality and says that the state shall not discriminate. And one of the grounds that has been stated is of sex. Okay. So there can be no discrimination based on a person's sex, an individual's sex. That means a discrimination between the male and female. Okay. But in the same sense, Article 15(3) that is there. Article 15(3) says that despite the prohibition of discrimination, okay, which Article 15(1) carries, which of course this prohibition is in a negative sense, means the state is not to deprive the women an equal status or an equal opportunity with that of men. The discrimination should not have a negative effect, but at the same time, Article 15(3) it allows the state or empowers the state to make special provisions relating to women and children. Although these provisions might result in a discrimination, but then this is a positive discrimination. What Article 15(3) is talking about is a positive discrimination in the favor of women and children. Okay. Article 13 states that the state shall in particular direct its policy towards securing. Article 13 comes within the directive principles of state policy. Okay. And it states that the state, when it is making its policy, it shall take care to direct its policy to in order to secure you know both men and women equally the adequate, the right to adequate means of livelihood. Okay. And then 39D it says that there should be equal pay for equal work for both men and women. Then Article 42 it talks about that the state shall make provisions for securing just and humane conditions of work and for maternity relief. Okay. So these are some of the articles that are there in our constitution that we see, talk about, of course, equality to, for both men and women. Okay. And also prohibit discrimination, based on the fact of one's sex. Okay. That discrimination is prohibited, but at the same time, discrimination that is positive in nature means to ameliorate the conditions of the women, or to safeguard their rights. Okay. A positive discrimination in the favor of women can be made, in the favor of women can be made as per the constitution. We already know that uh, due to many socio-economic political reasons, how the society in our country it has developed the culture, it somewhat degraded in terms of oppression towards women, the minorities, etc. Okay. Whatever factors they may be, and there were many factors which contributed to these to the sorry state of affairs regarding women and the scheduled caste and scheduled tribes, etc. But we know that as a matter of fact, women in our country have suffered a lot. Okay, and therefore, keeping in mind that, we see that these provisions were made by the uh, framers of the constitution, because they knew that any country's progress is dependent on, of course, the progress of every individual of that country. Okay, for every individual should get equal opportunity to progress, equal opportunity to grow, and shall also enjoy the rights equally, and equal rights should also, he or she should be he should be able to enjoy the rights equally, and should enjoy equal rights as well. Now, and this uh, cannot be more true than, for if we talk about women, because it's still, we see half of the women, half of our workforce of this nation. Okay, it suffered because of which, the effect of that was that the entire nation, in effect, it was uh, you know pulled back pulled back from from progressing towards a better future. Okay, now this was because, socially, there were many kind of restrictions on women. uh, Women were not allowed to study. Girl child was taken to be a burden, and there was child marriage. uh, the women, of course, if they are not studying, they are not skilled, etc., they were, of course, out of the main economy, isn't it? They cannot be a part of the workforce. If they're not part of the workforce, they have to be dependent on the men for their sustenance. If they are dependent, then automatically they cannot assert their rights. So there, this, every factor, it was working like a, like a chain in circles. Okay, it was running in circles, uh, within which women, and as a consequence, the entire nation was trapped. Even if we talk about the present environment, this is not only true about India, but uh, only because we are developing country, we face different kind of problems. But gender inequality and violence against women, it is you know it is a fact that even the many of the so-called developed countries, okay, they have to deal with. Okay, it's a problem there also. The only the level may be different. Okay, uh, because of their stage of development, they might have different issues to deal with in this problem than what we are facing. But the root problem, it still remains. Okay, this is why, even to this day, if you see the sustainable development goals that the United Nations has come up with, gender equality, and uh, prohibition of violence against women, these are some of the main goals. Okay, that we have to achieve. Okay, even under sustainable development goals, in order that this world progresses towards a more better and secure future. Okay, without giving adequate rights to women, the country cannot progress. Okay, now, because of these, of course, we know that, keeping the socio-economic, political plight of the women, and the problems that they were facing, keeping in mind those problems, the framers of the framers of our constitution, they put in these provisions, okay, in place, so that women's rights can be safeguarded. And taking this as, as a guidance, the legislature also, it uh, it enacted the National Commission for Women Act 1990. Okay, which provides for for the establishment of a national commission for women. Okay, to safeguard the rights of the women and uh, work for their welfare. Now, Section 3 of this Act, it deals with the constitution of the Commission. The Commission is the National Commission for Women. It is made up of seven people, uh, in which the chairperson, uh, she's nominated by the central government. Okay, she's nominated by the central government, and the qualification is that she has to be, committed to the cause of women. Now, this committed to the cause of women can be anything. It's very vague and a very open-ended, broad term. Uh, 3b, it says that, 5 members, uh, they are to be nominated by the central government, and these 5 members, they have to be, persons of ability, integrity, and standing, who have had experience in law or legislation, trade unionism, management of an industry or organization, committed to increasing the employment of women, women's voluntary organizations, including women activists, administration, economic development, health, education, or social welfare. But out of these 5 women, what is important for us to remember is that, 2 members, out of these 5 members, 2 members should belong to, the scheduled caste and the scheduled tribe. That means, 1 member out of these 5 members should, you know, belong to the scheduled caste, and another member should belong to the scheduled tribes. Okay. Now, this we have already done. 6 members. The last member is the member secretary, and he or she is also appointed by the central government. Okay, and this member secretary has to be, an expert in the field of management, organizational structure, or sociological movement, or he has to be an officer of a civil service of the union, or of an all India service. Okay, or he should hold a post, under the union with appropriate experience. Now, Section 4 deals with the term of office and the conditions of service of the chairperson and members, and the time period for which the members, they are appointed is, max a time period of maximum 3 years. Okay, the chairperson as well as the members, they cannot hold an office beyond 3 years. Okay, for a time period which exceeds 3 years. So 3 years is the maximum for which at a time they can be appointed, and they can, except the member secretary, the chairperson, and other members, they can resign, by giving a notice in writing to the central government. Now, the central government can also, remove from office the chairperson or a member if the said chairperson or the member, he becomes an undischarged insolvent. The grounds here for removal are the same as we saw when we were doing, the National Commission, the National Human Rights Commission, okay, NHRC. There also we saw the same grounds existed on which the president could have, or the president could remove the members of the NHRC. So those grounds were the same. Here also it's the same grounds. The first is if the member becomes uh, an undischarged insolvent, okay, if he gets convicted, if he gets convicted, or if he is sentenced to imprisonment for an offense which involves moral turpitude, if he becomes that of unsound mind, and he's so declared by a competent court, if he refuses to act or becomes incapable of acting, he is if he does not he does not attend three consecutive meetings of the commission, okay, without taking permission from the commission, then also uh, the member, in this case also the member can be uh, removed from his office. The last is that if, in the opinion of the central government, the particular member or the chairperson, he has abused, his position, okay, and in the opinion of the central government, the his continuance in office, it will be detrimental to the public interest, okay. So all these grounds from that have been declared from as in section 3A to F, they render a person unfit to discharge his duty. Okay, and therefore, when any of these condition is applicable or is true for the chairperson or a member of the commission, he can be removed from his office by the central government. Okay. Now, the proviso, it says that that no person shall be removed under this clause until that person has been given a reasonable opportunity of being heard in the matter. Now, this of course means that the person concerned, okay, whoever is, this is the proviso is mandating that the principles of natural justice, okay, it will be followed. That means any person who is going to be removed, he shall be given a reasonable opportunity to justify his actions, okay, or to counter the charges that have been made against him. This is a principle of natural justice that has to be followed in any any uh, in any process that takes place to for the removal of any person, okay. So this principle of natural justice has to be complied with in this case also. Now, section 5 talks about officers and other employees of the commission, okay, and it says that the central government shall provide the commission with such officers and employees as may be necessary for the efficient performance of the functions of the commission under this act. So it is the, again we see that it is the central government, okay, it is the central government which is providing the manpower resource to the commission, okay, the National Commission for Women. Now, Section 6 talks about salaries and allowances to be paid out of grants. And the salaries and allowances that are to be payable to chairperson and members, and the other administrative expenses, including salaries, allowances, and pensions payable to the officers and other employees, they shall be paid out of the grants referred to in subsection 1 of Section 11. And Section 11 says that the central government shall, after due appropriation made by Parliament by law in this behalf, pay to the Commission by way of grants such sums of money as the central government may think fit. Now, here we see, this can be one of the most, this is one of the most, you know, this is one of the biggest criticism of this, of the functioning of the NCW and this particular act, because here we see that the commission, it is totally dependent on the central government, okay. uh, of course the expenses have to be met out, okay, and the salaries, allowances, etc., that are there of the chairperson and the members and other other staffs and the administrative expenses, etc. It is, it is uh, it is meted out by way of grants, and those grants, they are given by the central government, okay, according to what it thinks fit. So of course it's not a particular a minimum fixed amount of money that is to be given, but it can vary. Okay, it can vary. So this makes the this restricts the autonomy of the National Commission for Women, and makes it totally dependent on the central government. Okay. Now, what are the functions of the commission? Okay, what are those functions that the commission discharges? So, Section 10 of the Act talks about the functions of the commission, and the functions that have been given are that the first function is that the commission, it investigates and examines all matters relating to the safeguards provided for women under the Constitution and other laws. Okay, as well as also it also studies, you know the existing provisions. If you will see uh, clause D, you will find that clause D talks about review from time to time the existing provisions of the Constitution and other laws affecting women, and recommend amendments thereto as to suggest remedial legislative measures to meet any inadequacies or shortcomings in such legislations. So one of the function of the commission is to investigate and examine all matters, okay, relating to the safeguards of the women, and also to review the constitutional provisions as well as other laws which affect women, which are made for their welfare, or which in any sense, affect women, their rights, and then recommend the appropriate measures that needs to be taken in that regard. Okay. Now, the second function of the commission is to present an annual reports, okay, to the commission. It can also present, besides the annual reports, the commission is also empowered to present other reports as and when it deems fit. Okay. Now, clause E clause E says that the function of the commission is to take up the cases of violations of the provisions of the Constitution and other laws relating to women with the appropriate authorities. So, if it finds that, you know a, a violation of the right of women, or of a law with regard to women has taken place, it will appropriate the it will inform the appropriate authorities, whether it is the police or any other authority that is empowered to take the necessary steps with to remedy those violations. Okay. Now, the commission is not only empowered to look into complaints, but in certain matters, it is also empowered to take suo moto cognizance of the matters. And these matters in which it is, empowered to take suo moto cognizance, they are, deprivation of women's rights. When there is a deprivation of women's rights, when there is a non-implementation of laws enacted to provide protection to women. Okay, and when there is non-compliance of policy decisions, guidelines, etc. Okay, in this case also, the commission, it is authorized to take up the non-compliance with the policy guidelines, etc., with the appropriate authorities. Okay, so that necessary measures can be taken to rectify the situation. Now, the commission, it also undertakes special studies and investigations into specific problems or situations arising out of discrimination and atrocities against women. So, for example, if the you know the if we see education, okay, the right to education or violence against women of a certain community or discrimination against women of a certain community, etc. What in whatever way the violation of the rights of women are there, okay, or violence against women is there, okay, or discrimination against women is there, then the commission it can initiate special studies and can investigate into those specific problems. Now the commission also undertakes promotional and educational research, okay, and it suggests ways of ensuring due representation of women, so that the the factors that are responsible for uh, hindering the progress of women, okay, they can be identified and then they can be adequately dealt with, okay. Now the commission it also participates and advises on the planning process of the socio-economic development of women. Now it is also authorized to you know go and inspect a jail, hostel, remand home, etc., wherever women are kept. Okay, and then if it finds that there is you know uh, the women there, their rights are not safeguarded, or they are being exploited, etc. Whatever way. There is a violation of human rights taking place of the women, then the commission can, consult the appropriate authority and ask them, for remedial measures. Okay. Now, one of the unique function that the commission is empowered to discharge is to, uh, it can also fund litigation involving issues affecting a large body of women, okay, a large number of women. If there is a cause that affects many women, or the women at large, etc., then the ncw can also uh, fund that litigation to safeguard women's rights. Now, these are some of the functions that have been listed under the consent provision in the Act. Okay. Now, the Act it also provides that you know the whatever annual reports or other reports that are submitted to the central government. Okay, the central government it will lay them down in the parliament, and then it will also explain the action that has been taken or that is proposed to be taken on the recommendations that have been given in those reports. Okay, and if the central government or if the government is not accepting the same, okay, then it has to also give the reasons as to why it is not accepting the recommendations given by the National Commission of Women. Okay, this is also true for the state government. Okay, so the state government also has to lay uh, with the state legislation the report that is given to it. Okay, and then if in case it is not accepting the recommendations of the ncw that has been stated in those reports, then it also has to state its reasons for non-acceptance of those recommendations. Okay. Now, when the state government, when the commission, the National Commission for Women is discharging its functions, etc., then for example, when it is investigating, or when it is inquiring, any complaint or any any case of discrimination against women or violence against women, then it will enjoy the powers of a civil court. Okay, so if it's the same that we saw in case of NHRC. Okay, and therefore the commission, it will have the power to summon a person to require the person concerned to give or to produce to give statements or information, or to produce documents. Okay, and so on and so forth. So these are like these are the powers that the NCW will enjoy in the discharge of its duties. Okay, it will be treated to be it will have the same power as as that of a civil court. Okay, when it is trying a suit. Now, section 16, it gives mandates the central government to consult the National Commission of Women in case of all policy matters which will affect women. Okay, so if the government is making any policy which can have an effect on uh, women, or it's deliberating any policy that is with regard to women, etc., then it has to consult the NCW also in that regard, so that it can know as to what will be the what is the position of NCW in terms of in terms of the policy effect with regard to women. So that is why the central government uh, has to consult the national commission on of national commission on women. Now, what are the major problems or the issues that concerns the working of the national commission for women? As we've already seen, you know one of the biggest criticism is that of financial independence. The commission is not at all autonomous, and autonomous here we can, or independence we can say directly in terms of both, uh, you know, the in terms of the financial, the uh, financial expenses also, or the finance that is required to keep it running, and also the members, because we find that uh, unlike the NHRC, which where there was a committee and the members they had certain qualifications, here even the qualifications are not that rigorous, and they are very ambiguous and open-ended, so which practically results in those persons being appointed as members of the uh, National Commission of Women, who are close to the government of the day. Okay, this is what practically happens. And we also know that it's entirely in the hands of the central government. Okay, who appoints the members to the commission. So the central government, in more than one way, it totally controls the working, the National Commission for Women, and therefore the National Commission for Women is not autonomous. We cannot say that it is autonomous and independent of the central government, okay, or the government. Now, other criticism in the working of the National Commission for Women are that the commission, it only enjoys the power to recommend, okay, amendments and to submit reports. It cannot take a binding decision, okay, or even the reports that they are that is submitted by the NCW, it is not binding on the the recommendations contained in those reports. They are not binding on the on the government. Okay, although the provision is that the government has to give the reasons for non-acceptance of the same, of the, that means non-acceptance of the recommendations, but that in itself does not give much teeth to the, to the NCW. Okay. uh, One more criticism is that NCW generally, it takes those matters which already come into light, okay, or which are highlighted, okay, and there are many cases of discrimination, okay, of violation of women's rights, etc., which regularly take place, and the commission has no role to play in those cases. Okay, generally it is only when the commission, we find it working only when some case related to women or women's rights has been highlighted by the media. Okay, then only the commission, it all of a sudden it wakes up. Otherwise we find that usually the commission, we don't hear the uh, we don't hear much of the commission doing any work. But these are some of the major criticism. Despite these criticism, I think the commission is doing is trying to discharge its mandate, uh, but it still is if we want to have an effective institution for which can play a major role in safeguarding women's rights and furthering women's interest, etc., then we have to bring major changes in the working of the National Commission for Women, and thereby in the provisions of the National Commission for Women Act 1990. So here we finish with our National Commission for Women. Okay, I'll be supplying reading material. So if you want to know more about the National Commission for Women, you can read those materials also. Uh, the provisions, they are very direct, and there is not much to deliberate in the working of the National Commission for Women. But you should know the challenges or the criticism that that is there in the workings of the National Commission for Women. So for now, this is all. Okay, so here we have completed our second last unit, and in the next session we will be starting with our last unit. Thank you.